Quickie. In addition to just the absolutely insane levels that enforcement of copyright infringement has gone to, there's also the controversy of taking copyrighted material for use in AI training. You could probably be forgiven for thinking that any use of, say, digital books that you didn't pay for would per se be copyright infringement. Not so, according to the HathiTrust case. The Authors Guild, several individual authors, and a few other organizations sued the HathiTrust digital library for using digital books that had been scanned by Google. They claimed that HathiTrust had pirated the books without permission, but the district court ruled that since the HDL's objective was long-term preservation and full-text search, and none of those uses were related to the author's expression, that this was a fair use exception. The plaintiffs appealed to the Second Circuit, who knocked it down again, saying that the HDL didn't add any new copies of the books into circulation. It was a similar situation when the Authors Guild sued Google for the same thing. Merely scanning the books wasn't an activity that needed the permission of authors or publishers. Again, both the District Court and the Second Circuit ruled against the plaintiffs. Digitizing, creating a search function, and displaying snippets of the book are all fair use. The Supreme Court denied certain these cases, and that, plus the fact that there's no circuit split, suggests that this is pretty strong precedent. You don't need permission from authors or publishers to obtain and use copyrighted material for non-expressive purposes. If no one is reading the books, they're not redistributing them, and they're not used to create derivative works, then it's fair use. It would seem that AI training falls under this category. Kadrey v. Meta is the case to watch for that. All other claims by the plaintiffs, including that the output of a large language model comprises a derivative work, has been thrown out by the court, as have similar arguments in other cases. But Meta obtained the books for the training without permission, and the plaintiffs say that's piracy. It's the only charge that wasn't dismissed because Meta didn't move for it to be dismissed. They wanted to be litigated to get a definitive answer on the issue. If the court follows these circuit precedents, Meta should win that. But the plaintiffs aren't going to go down easy, so this time, it might be going up to the Supreme Court.